Okay, I'll give a quick introduction to
what will happen here. When I met Chris Halbert at Cass Business School last year, we discussed that it might be a good idea to have a number of academic discussions moving towards a more policy-oriented environment, in this case Brussels. And it took quite some time to figure out what might be the best way to do that, and what I thought might be a helpful way would be to get academics from different disciplines to write succinct memos that would allow other people to take note of what has been going on in the last 20-30 years in those fields in terms of the relationship of academics within those fields towards the theme of maximizing shareholder value. Now, obviously, company law is a very important part of that discussion, and I've had the pleasure of working with Paddy Ireland before, and also of reading some of the magnificent writings of the people here on this table on the theme of company law and maximizing shareholder value. So what I'll do is I'll introduce the next speakers one by one and have them deliver their speech. To my right is Professor Johnston, Professor of Company Law, Corporate Governance, elected previously in Queensland, Cambridge, and Sheffield and Warsaw. He teaches in the fields of company law, corporate governance. He has practiced before as a solicitor. He's a research associate at the Centre for Business Research at the University of Cambridge. Also a member of Sustainable Companies Project, and who will now talk to us.
Thank you very much for inviting me. Thanks to Frank Bold and the University of Cardiff Business School. What I'm going to do in my... thank you for inviting me. Thank you, Frank Bold and University of Cardiff Business School. What I'm going to do in my short presentation today is to build on our two-page document, the Fundamental Rules of Corporate Law, and just really sketch out a few thoughts about the interrelationship between company law and shareholder primacy. I'm going to try and do it at a fairly light touch law level. I'm not going to dive deep into the details of common law, company law, you'll be glad to hear. Well, the starting point for my presentation is that company law already and has always established a structure which facilitates long-term investments, financial investments, physical investments, human capital investments. And those investments are allocated to different uses by managerial discretion. Managerialism, as Paddy told us, has always been at the heart of company law. And that managerial discretion allocates those resources so as to produce goods, services, perhaps employment, in order to meet society's present and future needs. So to bring this to the theme of today's conference, I'm going to say that meeting society's present and future needs is the purpose of the corporation. As we argue in Sustainable Companies, that is the reason for which we recognise companies. That is why society grants recognition to separate legal entities. Shareholders are one group that has a stake in companies. That is, they are one group whose interests are affected by what companies do. But, we can't say this clearly enough, in law, shareholders do not own companies. Shareholders own their shares, and their shares give them limited rights over companies. Shareholders cannot own companies. Companies are separate legal people. They do not have owners. Instead, shareholders have a limited collection of rights in relation to companies. Now, as we point out in the two-page document, shareholders will very rarely have actually put finance into the company. Much more commonly, shareholders will have purchased their shares on a secondary market. In other words, they will have bought their shares from someone else who may have put money into a company, or from someone else who's bought them from someone else, who bought them from someone else, and some way back in history, somebody put some money into a company. Now, not only will they not have necessarily contributed finance to the company, they can leave the company in exactly the same way that they entered it. That is through the secondary market. They can come in and out with nothing more than a buy or sell decision. Now, for historical reasons, for the emergence of the company in common law countries, at least, the emergence of the company out of partnership, shareholders have limited control rights over companies. This is what is mistakenly described as ownership. After all, shareholders own companies? No, after all, shareholders have the right to appoint the directors. They have the right to make certain limited decisions in relation to the corporation's structure. But those rights do not extend as far as taking part in management. Management is a matter for the managers. Managerialism, as Paddy told us, is at the heart of company law. Now, shareholders can use the rights that they have to make management, to make directors listen to them, or they can sell out to other shareholders who will use those rights if they don't feel like using them. So that's shareholders. What about other groups? Other groups also have a stake in companies. We call them stakeholders. We might say other groups are residual claimants. Other groups' interests are also affected by what companies do. Employees, they may be the most obvious. Consumers are affected by what companies do. Taxpayers, as we've recently seen, are very affected by what companies do if they're called on to backstop those companies to prevent the collapse of the financial system. Communities are clearly affected by what companies do. Societies are affected. And as we say in sustainable companies, future generations are also deeply affected by the way companies make decisions. So the expectations and interests of these groups, of these stakeholders, of these wider residual claimants could be protected in company decision making. They could be protected. Within law, there is no deep-seated objection. Our comparative company law analysis says these interests could be protected, but they're not. So my first point to make today is that company law is pregnant with possibility. It's full of possibility, it's bursting with possibility, because it allows for the governance of economic activity in pursuit of the public good. Companies are a structure which are designed, their purpose is to further the public good. And at this point, shareholder primacy comes into the picture. Shareholder primacy is not required by law. It is not required by law in any legal system that we've examined. And it completely sidelines the possibility of the corporation being used to govern economic activity in pursuit of the public good. The managerial discretion, which is at the heart of company law, which was recognised in these classic texts that Paddy referred us to, is no longer a benefit. It's no longer the distinctive hallmark of the corporation. Instead, it's become a problem. It's become the agency problem. It is the source of agency costs for shareholders who don't use their rights to protect themselves. In this account, in this strange neoliberal account of corporate governance, the directors become the agents of the shareholders. But they're not the agents of the shareholders in law. In law, we scratch our heads in puzzlement and say, where is this agency relationship? What does this agency relationship mean? It is not a legal situation. But this dialogue, this discourse has become so influential that it's become assumed that directors are the agents of shareholders. It's become assumed that the company should not be a managerial structure. It should not be something aimed at producing the public good. Instead, it should be more like a market. It should be judged according to market standards. It should be viewed as a flawed market, and steps should be made to correct that market to give the correct incentives to those concerned. And all of a sudden, shareholder value has become the purpose of the corporation rather than a byproduct of its success. It's become the goal rather than something that just happens when a company is well run. So shareholder primacy demands things which are very familiar to us. Managers should be made accountable to shareholders. They should be incentivized to produce shareholder value. We think of takeovers and the market for corporate control. We think of incentive pay, bonuses linked to share price. We think to stacking the board with outsiders who will keep an eye on these managers who can't be trusted and hold them accountable to shareholders. we think of activism by institutional investors, which will somehow bring into view a long-term perspective on how the corporation should be run. All of these things work very well in theory. All of these things seem to be lacking in practice and in our recent experience. So the effects of shareholder primacy are to reduce the corporation from a tool for economic governance into a mere accounting mechanism, into a mere financial device. And it leaves all of these other stakeholders to be protected either by specific regulation, as our neoliberal friends tell us, or by the vagaries of corporate social responsibility. That is, they will be taken into account if their interests can be considered in a way which is profitable. So this is the problem. Shareholder primacy is the main barrier to many things that we want in our societies. It's the main barrier to environmental sustainability, as we see through comparative analysis in sustainable companies. It's the main barrier to quality employment, as jobs are offshored to low regulation, low wage jurisdictions. It's the main barrier to quality products, as products are replaced more and more quickly, as life cycle analysis is ignored, as goods become throwaway. It's the main barrier to corporate financial stability, as we'll hear more of later on, as corporations leverage their balance sheets, take on debt in order to return cash to shareholders. And it's perhaps even the main barrier to macroeconomic stability, as the result of shareholder primacy is a massive polarization of wealth. So, to finish, what do I want? Because I was told I could make one wish at the end of my presentation. I want policymakers to drop the narrow focus on shareholders and to recognise that companies are the site of great interdependence and great possibility. I want them to recognise companies are the place where economic activity is governed for the public good. I want more policy imagination. We should stop equating shareholder value with short-term share price gain. We should start equating good corporate governance with the public good and achievement of the corporate purpose. We should start requiring processes by which the public good is constructed and identified through dialogue with everybody who is concerned or affected by the activities of corporations. Thank you.
Thank you, Andrew. Next speaker will be Jean-Philippe Robé, who is a member of the Paris and New York bars and a partner in a large US law firm. He regularly appears in court in complex international litigations. He is described as an expert in strategy by Paris Legal 500. He lectures in enterprise law, corporate governance in France, US, and Italy. Teaches law at the Paris Sciences Po Law School and at the PhD European University Institute of Florence. He also has published extensively in English and French on the notion of the firm and its role in law. I'll give you the floor.
Thank you very much. Lynn, I wonder what is left for us after your speech. So I will sound a bit strange to you because I will do as if I was speaking to the EU legislator, whatever that means, and not to a very group like ours. And after this excellent summary of the two-pager, and you have to do the two-pager and then probably to the sources of the two-pager if you want to go more into the details of corporate law as I described it. But I would like to bring home to you several points. I started this weekend with 2 points and I have 5, so it's clear that I didn't start earlier. My first point would be to say when there is issues in society, I tend to believe that it's better to attack the root of the problems rather than the symptoms. And we have plenty of difficulties. Financial crisis has been said, of course. The environmental crisis is a big one. The tax crisis is, of course, another very serious one. I mean, if you add them all, that will give a lot of work for many people at the EU governance level. And I'm not sure we are equipped to address all these problems. So one way would be to look at the root of the problem. And looking at the root of the problem, we have to look at the governance system in society. And here we are in the EU Parliament, one of the macro governance system, and in the environment of this macro governance system, of course, you get states and you get public organizations, other international organizations. But one thing which is probably missing in the thinking is that in this governance system, complex governance system of a society, you have firms. Okay, they are micro governance devices. They are not necessarily believed to be such and understood as such, but that's what they are. Governance systems. And I'm saying firms, I'm not saying corporations. It's very important, as you will see, to make the distinction. It's very important because today we take corporate governance as a proxy for firm governance, and that's part of the problem, of the root of the problem. So, trying to address the problem at its roots, I would like to bring my 2 points of the weekend to you, maybe in a provocative manner, so that you will have an interest in going further into the details. But I think they're really fundamental. One of them, it has been said already, but I want to insist on that, is that shareholders do not own firms or corporations. And firms are not owned by anyone. Okay? Nobody owns them. You always think that, well, how can that be? I mean, they are being sold all the time. No. What is being sold is the control of the corporations through a sale of the majority of the shares, which clearly can transfer the control over an organization which is called a firm. But the firm itself is not being sold. It is not an object of property right. What is an object of property right is the share. And it is very important, first and foremost, to say that it is fundamental to protect the property right of shareholders. They have a property right, it has to be respected, and it is very important that this is not disregarded when you propose changes in the legal system, because shareholders are fundamental contributors of resources to firms. It has to be said. But it's not because they own shares, with what has been said, the limited rights are attached to the shares, political and economic, but again, it doesn't give any property right over the corporation, which is not owned, or to the firm, which is not owned. And that's very important to keep in mind. I knew that Paddy would come with old stuff, because he told us in advance. So I decided, well, I'm going to put a trick to Paddy. Look at this book, okay? The nature of a corporation. You know it? Nobody does. All right. Guess what? It's 1897. It's a reprint. Now, the funny thing is that it has been published by the University of Chicago Press. Why did I say? What did I say? And it says there, so it ends point, 1897, and it says, a shareholder of a railroad company cannot use the cars at his pleasure. He can give no orders to the employees, and if he performs acts of ownership, he is a trespasser. A shareholder acting as an owner is a criminal. That's what it says. I mean, the book is here, all right? It's an old book, but it's very the best book I've ever read. Everything is there. Everything's there. Well, I'm not sure. Anyway, a shareholder who acts as an owner is a trespasser, and here comes the genius of agency theory. If I, as a shareholder, I act as an owner, I go to jail. Well, let's find an agent to act on my behalf as an owner. This is brilliant. This is brilliant, because what shareholders can do directly, they found someone to do on their behalf. And that's where agency theory is fundamentally wrong. It starts from the premise that shareholders own firms. Obvious, everybody thinks so. Well, therefore, people who manage firms are the agent of the owner. I mean, they don't own these things, so they've got to be the agent of someone. And if they are the agent, well, agency relationship, we know exactly what that means. The agent has to manage in the interest of the principal. Obvious. It's all obvious, except that it's all based on either a mistake or a lie. Okay? If it's a mistake, it's a big one, because it was down there in the library. Okay? So it's hard, but you could miss that one. Anyway, so as I started saying that shareholders are owners of shares, I want to emphasize that in the management of the firm, of the corporation in particular, those who are in charge, empowered, have fiduciary duties towards the contributors of resource that shareholders are, especially of the primary market for shares. But because of the construction of the corporation, you also need secondary markets, because that's one of the reasons why people invest in the primary market in the first place. So you also need to preserve the right of shareholders, even if they don't contribute anything. When you listen to people on TV or read the press, you see that shareholders are always presented as investors in companies, so they provide capital to companies. It's sometimes true. On a macro basis, it is not true, because more wealth is taken out of companies than is brought in. So it's, the net effect is not positive. But it is certainly not true on the secondary market. But the shareholders have a right, and therefore they are the beneficiaries of fiduciary duties. And Lynn could go, I don't know if they're going to do that, but the managers have really obligations towards shareholders. But it is not because there are obligations towards shareholders that they do not have, or could not have, or may not have, or should not have obligations towards other constituents, not of the corporation, but of the firm. What is important is the firm, and that's where my second weekend point comes in. It is absolutely fundamental when you think about governance issues, not to make the confusion between the corporation and the firm. What really matters is the firm. The economic organization, which is producing goods, distributing goods, having the economic activity which has a negative or positive impact depending on how you account for the cost, etc., is the firm. It's not the corporation. The corporation basically does nothing. A corporation is a legal device to get equity capital which is being used for the financing of the corporation. It's a financing device. But the contracting activity, buying, selling, renting premises, coffee, finally. And they bring it when I speak. I mean, it's just that gives me 2 more minutes, right? So the real thing which is being managed is the firm, not the corporation. Okay? And in the management of the corporation, of the firm. Sorry. In the management of the firm, there are many more interests to take into account. That's what people see as stakeholder theory. I don't like the name because I don't see for me the most pressing issue is the environmental, natural environmental disaster, and seeing the environment as having a stake in firms, for me, is a bit of a problem. So it's really a question of taking into account the interest being affected by the firm management, and therefore not giving always, in all circumstances, the primacy to shareholders. Opens the possibility for these micro-governance structures which firms are to take into account other interests as well in the management of the firm, with the outcomes that for the macro-governance system like the EU Parliament or the EU Commission, there is less work to be done. Now maybe I've said something very bad here, because that means there's less of a role for the macro-institutions, and maybe they want to have more of a role. But I can tell you that with the very defective firm governance structures we have, without addressing the problem at its root, the European institutions are creating more problems than they can ever handle. Enjoy your coffee. Thank you very much.
Thank you, Jean-Philippe. Next speaker is Lynn Stout, Distinguished Professor of Corporate and Business Law at Cornell. She holds a BA Summa Cum Laude and a Master's in Public Affairs by Princeton University and JD Law School. She's an internationally recognized expert in the field of corporate governance, securities regulation, financial derivatives, law and economics. She sits as an independent trustee for the Eaton Vance family of mutual funds, member of the board of advisors for the Aspen Institute, executive advisor to the Brookings Institution Project of Corporate Purpose, and research fellow for the Grutter Institute for More Research, and also the author of a rather recent book which is called Shareholder Value. And then talk to us.
So thank you very much. I basically want to second everything that Andrew and JP have said about the nature of the law, which gives rise to the interesting question. How could the business world have embraced a way of thinking about corporations for the past 20 years that is so, and I will say this is true, clearly inconsistent with the actual rules of corporate law? And just to quickly emphasize, it is a legal fact that there is no legally enforceable duty to maximize shareholder value. That's just a factual statement, and it's accurate. It is a fact, legally speaking, that shareholders don't own corporations. It's really not disputable to a lawyer. It is also a fact that shareholders are not the sole residual claimants in corporations. You see that said all the time, but it's actually not legally true. As a legal entity, a corporation is its own residual claimant, and it's the board of directors that decides what to do with the firm's residual, and they have the legal discretion to allocate it among many different groups. And finally, it's a legal fact that shareholders are not principals, and directors and executives are not their agents. So how did we collectively get the law so wrong? I do have a hypothesis, and my hypothesis is, okay, how many people are economists? Okay, with all due apologies, if you're going to talk about corporations, you need to go to law school first. Because corporations are legal entities, and after studying the history of this mistake, I've reached the conclusion that a big contributing factor was that, frankly, some of the pioneers of today's modern approach, including both Milton Friedman and Michael Jensen, are economists who never went to law school. And they thought of corporations as gigantic sole proprietorships because they understood what sole proprietorships do. Now, that's not the only reason we got to where we're going today. It also turns out that this very simple model was incredibly useful and profitable to certain very powerful interest groups. But I think if you look back at the history, there's actually reasons why the business world, which I didn't realize it went back to, what did you say this was published in?
1897.
But I can assure you that at least for most of the 20th century, it was well understood that corporations were not sole proprietorships and that shareholders didn't own them, and everything we've been talking about was well understood. It sort of got forgotten with the rise of Chicago-style law and economics thinking. But now we're at the point where we have to ask ourselves, well, what were the consequences of our embracing this quote, modern economist-centered model? And the consequences, I think, have been very significant. Corporate law, per se, has not changed all that much, at least in the United States. But there are other elements of law, and certainly elements of business practice, that have changed dramatically in the last 20 to 30 years as a result of the intellectual embrace of the shareholder value model. And I think that these changes in regulatory approach and these changes in business practice have been both incredibly powerful, and also, I think the evidence is mounting up, perhaps very destructive. And the two areas I simply want to highlight, actually three things that have really changed as a result of the acceptance of this model. Number one, we've seen the rise of a cadre of very short-term activist shareholders who didn't and couldn't exist until the last 20 years, in part because, at least in the US, the SEC's proxy rules discouraged it, and that is the rise of activist hedge funds who now also coordinate the activities of activist mutual funds and pension funds especially. And all of these investors have become much more short-term in focus as a consequence of, an unintended consequence of, the dramatic reduction in transactions costs that we've seen in the market. So where in 1960 the average share of stock in an S&P 500 firm was held for, get ready for this, 8 years, today the average holding period for a share of stock is 4 months. So we have much more short-term shareholders, and they have much more power. Another critical structural change has been the way we compensate executives. And there was a time when executives were paid relatively modest amounts by today's standards that were very insensitive to objective performance metrics. Then, many people are not even aware of this. I think the watershed moment was in 1993 when the US Congress embracing this shareholder value model, changed the US tax code to require companies, public companies, to tie executive pay to so-called objective performance metrics to get deductibility. And that was where we see CEO pay, which at that point was relatively insensitive to share price performance. We're now in a world where 80% of the payments that are made to CEOs are based on share price performance. And I can't imagine anything you could do that would be more likely to ensure that corporations pursue shareholder value as an objective. And of course, these pay structures have been embraced around the world and are now routinely recommended by executive consultants. And finally, the third change is just, we've simply had a generation of business leaders who went to law schools, business schools, and they graduated from economics departments where they were taught that the law required them to maximize shareholder value and that this was a good thing for society. And they're now our business leaders, and inevitably this belief system is going to affect their behavior. All right, well, where has this gotten us? There's no shortage of anecdotal evidence that our business world and our corporations in particular are not performing for us the way we want them to. We can start with Enron, and we can work on to WorldCom and Tyco. We can get to the 2008 crisis, which many people believe was driven by the fact that the banks had become public corporations or were responding to short-term shareholder pressures. We could throw in the BP oil spill, which has been directly attributed to short-term managerial behavior and risk-taking. And then we can throw in, JP Morgan's London Whale and a few other assorted anecdotal results. But let me give you some hard figures to back up this sense of malaise. In both the UK and the United States, and I believe also in the EU, but I don't have hard figures, the number of public companies is dropping dramatically. In the past 15 years, the number of public companies in the US has been cut more than in half. It's dropped by 55%. I believe you'll see comparable or worse patterns in the UK. The life expectancy of large companies has dropped from 50 to 60 years in the middle of the 20th century during the managerialist era to, can you believe this? The life expectancy of a Fortune 500 company today is 15 years. I can't even get my kid out of high school in 15 years. I can't imagine how you can do truly long-range planning in a business world where the odds are your Fortune 500 company won't be a Fortune 500 company in 15 years. And finally, and this is both in some ways of most concern, at least to me, but also it's what gives me the most hope that we can make progress, returns to shareholders have declined. All of this maximized shareholder value thinking has actually ended up hurting long-term diversified shareholders. Sure, it's made a lot of money for some short-term shareholders, especially some hedge funds, and it's made a lot of money for executives whose compensation is tied to relatively short-term share price changes. But returns to public investors have actually declined significantly. And I ran the numbers through just a week ago. I went and looked at the S&P 500 total return, and what I found was over the past 20 years, it's produced 6.8% compounded annual returns to investors. And in the 40 years prior, which included the dreadful bear market of 1973-1974. So you understand that 20 years includes the stock bubble of the 1990s and recent returns, and it's still only 6.8%. And then 40 years before that, shareholders got 7.2%, which is a significant, almost a 10% decline in stock performance. So I'm simply going to finish up. The reason why that fact makes me optimistic is it suggests to me that we collectively can do better. Business can do better, and that includes doing better for shareholders. Fixing the structural obstacles that I see to truly good corporate performance is a win-win. If we can address these problems of short-termism, if we can address these problems of ignoring external impacts, if we can address these problems of neglecting and even abusing important stakeholders like employees, communities, customers, and the environment, we can get results that are better for just about everybody. But where is one good place to start? Here I would like to echo Andrew's wish. I think it would be extremely helpful if we can move our policymakers away from the language of shareholder value maximization and toward a more nuanced view of the purpose of the corporation that's not only historically more accurate, legally more accurate, but also, I think, going to produce better results for shareholders along with pretty much everyone else. So there you go.